we are going to start with Krueger versus Willowood. Case number 18CA0065M. Each party is represented by counsel. It's my understanding that Attorney Jenny is not going to be arguing.
That's correct, Your Honor. My name is Jillian Deinhardt. I'll be arguing on
All right,
behalf
well,
this morning.
that's fine. Each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes, for rebuttal. If you're going to reserve time, let me know, and I'll try to keep track of that for you. We have read the briefs, and we are prepared to proceed if you are. Oh, excuse me. I'm going to start the clock because I forgot my legal pad. I want to take some notes while you're arguing. Let me get that. Mr. Carr, I know you're a lot like me, but have you ever forgotten your legal pad in the back?
I'll talk to you afterwards.
All right, if you're prepared, we are.
Thank you, Your Honor. May it please the Court, I'm Jeffrey Krueger, Executor of the estate of Camilly Valente. I would like to reserve 3 minutes of my time for rebuttal.
Very good.
Thank you. The trial court abused its discretion in summarily barring and disqualifying myself from actively participating as trial counsel in this matter. Disqualification of a party's attorney is a drastic measure that requires a court to avoid an overly mechanical adherence to the disciplinary rules at the expense of a party's right to freely choose their attorney. The court must always be mindful of the possibility of misuse of disqualification motions for strategic reasons, and the court must consider the rationale behind the advocate witness rule embodied in Professional Conduct Rule 3.7. This court has previously held that a trial court should disqualify counsel if and only if the court is satisfied that real harm is likely to result from failing to disqualify. The appellee, as the moving party, is required to provide evidence that a need for disqualification actually exists. A party's mere declaration of an intention to call opposing counsel as a witness is an insufficient basis for disqualification, even if that counsel could give relevant testimony. Here, Rule 3.7 of the Rules of Professional Conduct does not apply to myself where the attorney is a party to the action. That's because in this instance, my testimony would be that of the executor of the estate of Camilly Valente, not as the attorney for the estate of Camilly Valente. Further, the policy considerations underlying Professional Conduct Rule 3.7 do not apply or are not implicated to a significant degree where the attorney is both the litigant, the advocate, and the witness. And that's because the interests of the client and the adverse party to the witness advocate rule is designed to protect and not imperil when the witness is also the litigant. It's clear that if I were to take the stand, it would be in my role as the executor of the estate of Camilly Valente. The issues that were identified with regard to myself was one, whether I was in fact the executor of the estate of Camilly Valente, which is an uncontested fact. Two, possible estate administration issues and bills incurred by the estate, and things particularly relevant to the estate. At that time, a jury would not be confused. The jury would know clearly, upon hearing the caption of the case, that my role is that of the executor, upon seeing me identified as a party, as the executor of the estate. The likelihood of confusion is not caused by the clear demarcation of my role as the executor of the estate. The jury would be able to understand that I have an interest in the case in my role as the executor and can evaluate my credibility should I testify based upon that role. Secondly, the lawyer-litigant witness rule the demarcation avoids the risk of apparent confusion of roles and conflicts of interest. I've yet to see a case where a court has declined the ability of the attorney to also serve, an attorney advocate or attorney litigant to also testify as their own client.
Is there an issue as to whether or not you were actually disqualified since the court let you participate and assist the lead counsel in this case?
Your Honor, yes, disqualification is clearly what occurred. I'm not able to participate in voir dire. I cannot make an opening statement. I cannot make a closing statement. I cannot object to a witness's testimony or evidence. My role, I cannot question a witness or cross-examine a witness.
But there was a lead counsel on the case.
There is a co-counsel on the case. Mr. Condeni is my co-counsel along with Mr. Valente. If you look at Rules of Professional Conduct 1.1, competence would require me as someone who's never done a wrongful death case, in 33 years of practice, allows me to be a counsel if I obtain the assistance of one, competent representation through an attorney established competence in the field of question. I do not have established competence in the field of question, wrongful death cases. Accordingly, I would not represent myself because I believed it would have violated Rule 1.1. So I sought someone who did have established competence in that area. It does not mean that I waived my right to participate as counsel, either pro se or counsel in this action to represent the interests of the estate that I represent. If, however, professional conduct rule does apply, Rule 3.7, the proper procedure was for the trial court to follow in determining whether to disqualify who has been called is to determine whether the attorney's testimony is admissible and determine whether the attorney's testimony is necessary. In order to determine whether a lawyer is likely to be a necessary witness, the trial court must first determine that the proposed testimony is material and relevant to the issues being litigated and that the evidence is unobtainable elsewhere. Here, the trial court failed to conduct such an analysis. There is no evidence in the record, either in the trial court's decision or in the transcript before the trial court, of any consideration of whether the evidence for either Mr. Valente or myself was unobtainable elsewhere or uncontroverted. As I've mentioned, my status as executor is uncontroverted. Mr. Valente's status as the grandson of the decedent is uncontroverted.
Counsel, I'm going to interrupt you because it sounds like the argument you're making is that you didn't need to appear as a witness.
The witness list lists everybody who's potentially going to be a witness. I don't know that I would have appeared as a witness or that I will appear as a witness. If I do appear as a witness, it would be on very limited grounds, Your Honor, because even my personal observations, let me backtrack. There are two issues that they've raised. One is my efforts to investigate what occurred. Well, those, I believe, are all covered by attorney work product privilege. So there's a quite serious question of admissibility, which would go to the necessity grounds. Secondly, whether or what occurred or what I observed, those things are obtainable from other witnesses who visited Mr. Valente at the nursing home, who visited Mr. Valente at the hospital. Those other witnesses can provide the same testimony I could provide on what they observed. So it is obtainable elsewhere. I am not a necessary witness as described in Rule of Professional Conduct 3.7.
Okay, even though you put yourself down as a witness.
We had to list everyone who was a potential witness. I could have listed Ms. Jenny as a potential witness because she was there and could identify the photographs of Willowood because she's depicted in those photographs.
Did either side talk about the possibility of withdrawing yourself as a witness for either witness list with either party?
I think the fact that it was immaterial because the appellee had also listed me as a potential witness. So their ability to designate that for strategic reasons would not made it immaterial whether I was withdrawn on my list or not. With regard to Mr. Valente, the trial court also abused its discretion in summarily barring and disqualifying him from actively participating as trial counsel in this matter. The record before the trial court is devoid of evidence on which the court could base its determination that the testimony of Attorney Valente is admissible and necessary. They've identified 3 areas to the trial court on which Attorney Valente may provide testimony. That he is the grandson of the decedent, it's uncontested. Clearly an exception under Part 1 of Rule 3.7a. The authentication of photographs. Other people could also identify that these are in fact photographs of the Willowood facility. And thirdly, that he delivered the preservation letter to the appellee. Even in appellee's motion, they identified that it was delivered to a woman named Corey Ladea, and her deposition testimony acknowledges that. So that testimony was similarly available elsewhere. The issue of admissibility with regard to Attorney Valente's testimony runs into at least 3 problems, if not more. It would run into the issue of attorney work product, it runs into the issue of hearsay, and it runs into the issue of cumulative testimony, because it would just mount on what other people had already testified to. Ms. Ladea, other employees of Willowood with whom he may have talked and doing his investigation, and that's not to mention possible issues regarding relevance and materiality. The trial court here failed to engage in a specific legal analysis intended to meet the requirements of Rule 3.7. A decision is unreasonable if there is no sound reasoning process that would support that decision. And that comes from the case that I've recently brought to the court's attention, Champoir, decided by the 8th District Court of Appeals on June 6th. Nothing in the record would support the trial court's finding that either Attorney Valente or I are necessary witnesses under 3.7. As a result, the trial court erred by failing to conduct the proper analysis to determine whether either of us, whether grounds existed for the disqualification of either of us. As a result, Your Honor, the trial court abused its discretion when it summarily barred myself and Attorney Valente from substantively participating as trial counsel in this matter. Accordingly, we pray that the court reverse and vacate the trial court's July 26, 2018 judgment entry. Thank you.
Thank you. You'll have 3 minutes and 22 seconds left for the rebuttal. And counsel, you'll have 15 minutes, but if you could please state your name again.
Thank you, Your Honor. My name is Jillian Deinhardt. I work with Attorney Jenny, and she's asked me to cover this morning. I represent Willowood Care Center.
All right, thank you. You'll have 15 minutes.
Thank you, Your Honor. I'd like to start by just saying that this is an abuse of discretion standard. It isn't just that the trial court got it wrong, but that they were unconscionable in this decision making. And I think that the evidence that we presented before both the trial court and in the appellate briefs demonstrates that there's some real issues here. As Mr. Krueger has mentioned, both are family members and both had a dual role before, during, and as this process continues as a family member investigating the death, visiting Mr. Valente, to the point when this attorney-client relationship occurred. It's unclear to us when that attorney-client relationship occurred. Therefore, as far as the work product defenses, so to speak, that's something that deserves to be investigated, and certainly it's not something that we would intend to erode upon them being called as witnesses. And again, they were listed as witnesses in their own right by plaintiff's counsel, so clearly there are elements of their testimony that are outside of work product. Now, counsel stood before you today and said that this decision by the trial court impacts the plaintiff's right to freely choose counsel. That clearly did not occur here. As your honors are well aware, the trial court made an order that says that you may not actively participate in trial. You being Mr. Krueger and Mr. Valente, of course. They are not allowed to essentially take action before the jury. And that falls right in line with the purposes of Rule 3.7, which you don't want to confuse the jury or make it unclear to a jury when a statement by an advocate witness is something that should be taken as fact or as argument. Now, the trial court is happy to allow them to continue to sit at the table almost as if a second chair would. So therefore, the argument that they're not allowed to participate in trial, to me, is disingenuous. They have every possibility to prepare every witness, to create strategy for cross-examination, for direct examination. They have the possibility of arguing motions before the trial, so long as it isn't before the jury, is at least how I would interpret that ruling by the court. The choice of counsel by the plaintiff is still readily intact. They're still able to have Mr. Krueger and Mr. Valente represent the estate. Not to mention, the attorney that is not with us today, Mr. Gundeni, has taken, I believe, 15 of the 16 depositions in this case. Although he's been characterized this morning as co-counsel, truly he has been the lead counsel in this, and he was the person that Mr. Krueger went to under the rules of professional conduct with a understanding of wrongful death litigation. That is the person the estate chose to represent them. To the extent that this has been argued as a disqualification case, again, I think is disingenuous because there is no disqualification here. They are still allowed to participate. The primary counsel is still participating. As far as choice of counsel concerns go, there are none here.
And I apologize if this is clear in the briefs, but how did we get to the point where there was argument or discussion about disqualification of both attorneys, and did that occur at the same time? I'm trying to put myself.
It's not clear in the briefs, Your Honor, exactly how we got to that point. I think that there was a lot of discussion about specifically Mr. Valente's role in serving the preservation letter. That's my recollection.
Okay, and I should qualify that question with, what does the record reflect about how we got there? Ways that we could get there are, we were at a pretrial and it was on the record, or we were specifically there on behalf of Willowood's motion to disqualify.
Mm-hmm. It was at a pretrial, Your Honor, and that's how it got there, and the court made kind of a preliminary finding. I believe that was on July 2nd.
On the record.
And then, yes, and then the court asked for briefs. So both parties presented briefs. Now, that kind of leads me into the argument by Mr. Krueger that the court didn't have enough on the record to make that determination. The court doesn't need to hold an oral evidentiary hearing to determine whether or not there are grounds for disqualification. The court did ask for written briefs. Written briefs were provided, and the court found that that was sufficient. Those written briefs did relate back to the deposition testimony of Mr. Valente, Antoinette Valente, as well as, I believe, Mr. Krueger. So there were excerpts of depositions, at the very least, attached to those briefings. And further, no evidentiary hearing was requested below. And it is my understanding here in the 9th District that an evidentiary hearing would need to be requested for a disqualification case in order to make that requirement and have that addressed on appeal. And that's in Sparrow versus Abney, which is 2015, Ohio 4671.
Were there evidentiary parts attached to the briefing?
Yes, Your Honor. So it is our position that there is certainly not a final appealable order here because there was no specific disqualification of these attorneys. To get to the second part, essentially, that the testimony needs to be admissible and necessary, we don't disagree with that standard. We simply believe that the testimony of Mr. Krueger and Mr. Valente is necessary. Mr. Krueger did knock on some of the points that we would be looking for as far as his testimony. And we did put him on our witness list, and we understand that he would be talking about damages, but as soon as he gets on that stand, as called by plaintiffs, we're not entirely sure what he's going to talk about. We did take his deposition, but because he's a family member, he has lots of kind of outside familial damages testimony he could give. We also understand that Mr. Krueger wrote Mr. Valente's will. There is a certain consideration here about Mr. Valente's cognizance. He was alleged to have been left out on a patio with no ability to get back inside, without the wherewithal of coming back inside. Whether or not Mr. Valente was competent is a real issue here. Mr. Krueger has firsthand knowledge of his competence based upon the legal analysis he would have had to do to write that will. Beyond
Counsel,
that,
before you go on, I'm just trying to figure this out. So you say there's no actual disqualification here?
I don't believe there is, Your Honor, because they're still allowed to, the court, I believe, calls it passively participating.
If that's the case, why are we looking at what's required under disqualification for necessary and admissible?
Quite honestly, Your Honor, I'm covering all my bases, but I don't think we should be here at all today. I think that this is a case that the plaintiffs have been able to choose their own counsel, that counsel will be able to participate throughout the trial in every aspect except for questioning witnesses. I don't think that we should be looking at this under 3.7. I think that this is just...
So you're saying, are you arguing that a trial court at any time would have the right to do that with attorneys? In other words, my concern is, okay, if we don't look at this as a disqualification, then what standards do we use to tell attorneys you can passively be an attorney, but you can't actively be an attorney? That seems to be a problem.
I completely understand, Your Honor. However, there's no case law indicating a disqualification case where this has ever been done before. There is no precedent for this, and that leads me to believe that's because this isn't a disqualification that gets up to the appellate level. Now, I understand your concerns about what standard you would use, but I think that it's really unusual for counsel to be listed on their own witness list. For instance, Jillian Deinhardt, I'm going to get up and I'm going to advocate for my client from the stand in a narrative statement.
If it's your suit, if you're the plaintiff, why is that unusual at all? Especially in muni court, I dealt with it every day.
Absolutely. In muni court, I would certainly agree with you. But this is an estate, Your Honor. The executor is not the party. The estate is the party. That's not the case. That's not what's happened here. These would be people that are getting up in an advocate role, perhaps in front of the jury, in front of witnesses, questioning people, and then getting up on the stand and sitting down and essentially giving the same testimony as they've just reiterated in questions and showing the jury that they are both an advocate and a witness. Neither of these people here are named parties in this suit, and that's how it's different than a muni case and how it's different than nearly any disqualification of case that's come before the state. This is highly unusual and created in part by their own acts in putting themselves on a witness list and their intense factual involvement before this case was filed.
So were the witness lists filed simultaneously?
I believe they were, Your Honor.
Okay. Because I was wondering, I asked you the same question, what if everybody just agrees that he can't test, or they're not going to be called as witnesses?
Mm-hmm. I think that there could be potentially some areas in that we would say, okay, maybe Mr. Krueger isn't going to be called as a witness for damages, because there are overlapping witness statements about damages, but I do think that his testimony is still necessary on competency when the will was drafted and carrying forward, and to the extent that he was not the attorney at the time of the investigation within the family and looking at autopsy records, that would be important too. As for Mr. Valente, his testimony is necessary because they brought a spoliation claim against Willowood. And that spoliation claim is based upon the delivery of a preservation letter for video from the nursing home at 5:30, I believe on a Friday of a holiday weekend. By the time the preservation letter made it through the IT department, etc., the video was already overwritten. And they've alleged that was willful conduct on behalf of Willowood. Now, Mr. Mr. Valente, through his deposition testimony, we know that before he served that preservation letter at 5:30 upon Ms. Ladaya, as Attorney Krueger had stated, he wandered through the facility, he stopped, he talked to people at a nurse's station, he talked to people out on a patio, all people who are employees of Willowood who he cannot name, and we do not know who they are. So to the extent that there's some hearsay problems with that testimony, that's dissolved by the fact that he couldn't identify, he couldn't tell us who he talked to. We have no idea who those people are. So his testimony about those conversations would certainly be admissible as those people are unavailable. And since it wouldn't be work product, because there are theoretically our employees, as he's testified in deposition.
Does Willowood dispute being served with the preservation letter of such and such a time? I can't understand if that's an issue, because I believe counsel for the other side indicated that that's not an issue.
It's not an issue in the fact that we agree that we were served at 5:30.
Okay.
It is an issue whether or not we were willful in failing to preserve. In other words, there may be arguments presented at trial that Mr. Valente could have given this to us at 4:30 when administration was still in the building, when IT offices weren't closed, when we still could have reached out. But instead, he went through the facility, talked to various of our employees, despite knowing that he was bringing suit, and waited until after the administration offices were closed to serve it to a nurse on staff. That would go to our willfulness argument in the sense that we didn't try and delay getting this video. We could have done more had you provided us in a timely manner. That also ties hand in hand with some of the testimony that Mr. Krueger might be able to provide as far as when the family became on notice that they were intended to file suit, when they realized that there may be video to be preserved here or documents to be preserved here, and what delay may have been on their behalf before serving us with that letter.
You got a little under 2 minutes left.
Okay. I'll wrap up with some of the arguments regarding Mr. Krueger's testimony as an executor of the estate. Some of the cases that he cited to in his brief do not state that an attorney can act in as an advocate witness for anyone other than in their personally named representative. So for instance, they cited to Horan versus Board of Education. In that case, a mother was acting as counsel for herself as well as her disabled child. She also had co-counsel on the case that was not related to the parties. The court in Horan found that the mother could not represent the family. She could represent her own interests, but then also found that there was no substantial hardship to her disqualification because there was another counsel of record that was there, that was their counsel of choice, that could make these arguments. That is the same here as an executor of the estate. If Mr. Krueger gets up and testifies, and yes, he's testifying as executor of the estate, that doesn't mean that he should also be able to stand up from trial table and cross-examine someone else or make an opening statement. He would not be testifying as a party, and that's the difference. The executor is not the party, the estate is the party. Counsel also cited to Michael Harvey, LPA versus Revita, 2012, Ohio 2776. That case does not squarely on point here about whether or not the attorney could testify on behalf of the LPA because that fit squarely with one of the exceptions of disqualification when testifying about fees.
Counsel, you used your time.
Thank you very much.
Thank you. I show 3 minutes and 22 seconds left for rebuttal.
Thank you, Your Honor. Let me clarify one thing. Mr. Valente was left out on a patio on an 85-degree plus day with a heat index near 100 degrees, who was non-ambulatory, confined to a wheelchair. Competence is not an issue here. Gross neglect is an issue here. Secondly, we believe the evidence at trial will show that Willowood actually had people come in on the Saturday following receipt of the notice to preserve evidence, manipulate the hard drive on where the video was stored, and destroy that evidence. That's the willfulness. Mr. Valente had nothing to do with either of those issues. is not a witness to the willfulness one way or another. As counsel said, there is no question that the letter to preserve evidence was delivered and received by Willowood. It's uncontroverted fact. I'm not a family member. I'm not a son, grandson, son-in-law, anything that qualifies as a typical family member. And counsel has conceded my role as an attorney for Mr. Valente at the time I drafted his will. As soon as that happened, work product attached. Further, it was clear from the time that I was the identified executor of Mr. Valente's will. So it was normal, it was customary, and it would be reasonable for people to come to the person identified as the executor after he's passed away with regard to decisions that had to be made with regard to his estate. Is this a disqualification? Yes. Nowhere on my borrowed card does it say that I may appear in court only for the purpose of sitting and passively participating in trial. I'm entitled as a member of the Bar of the State of Ohio to come before the court and advocate both for myself and for a client. Counsel argues that the Harvey case is distinguishable, yet if you look at the Rule 3.7, it allows a lawyer to come to collect their fees. But if you are a limited liability company as the lawyer to whom the fee is owed, that requires that it be represented by an attorney. That's not covered by the plain express language of 3.7. Counsel also neglects to point out the Nichols case, which is very similar. A trustee in bankruptcy, a fiduciary relationship, was able to act as both counsel and testifying witness at the bankruptcy court proceedings. That is what is similar to this case. Finally, if you look at the wrongful death statute, I, as the executor of the estate, am the only person who can bring a wrongful death action. It can't be brought by his surviving daughter. It can't be brought by grandsons. It can't be brought by his son or his brother and sister. It has to be prosecuted through me, the executor of the estate.
Counsel, I understand what you're saying, but to me, it's always been complicated with that, because technically you're a nominal party. And so you don't really have an interest other than the fact that you have a statutory right to bring the suit, right?
No, I have an interest, Your Honor, because not only do I have a statutory right to bring it, I also have an obligation as the designated fiduciary by the probate court to prosecute this in a proper and full manner.
I understand, but what I'm asking you, I guess, is when she says the real party in interest, I think what she's saying is the real party in interest is the estate.
Yes.
Okay, so why do you get to have an attorney of your choosing as the executor for you, not for the estate, but for you?
Because when you look at the case law, Your Honor, an executor cannot bring a case pro se unless they are an attorney. It is required that the executor be represented by an attorney. Could I represent myself? Yes, no question. No question, except Rule 1.1 and the competence standards. So I went and got co-counsel. I have co-counsel in probating the estate as well, because I'm not a probate attorney. But there is no prohibition against an executor attorney prosecuting a claim in name of the estate.
Of course not. But the problem comes in, and the issue here is the executor is not always a witness
No.
in the wrongful death.
But that obviates the requirement of 3.7. Because what you have in 3.7 is a concern of judging the role between the attorney and the witness. Here, I'm the designated party. There is no question where my interests lie. And they're subject to cross-examination. They're open for the jury to see. When the case gets read, it will be read as Jeffrey W. Krueger, executor of the estate of Camilly Valente versus Willowood. So there is no question as to where my interests lie, and that is why 3.7 does not apply in the case where it is a lawyer, litigator, witness. Your Honor, if I may just conclude.
You're way over time. but
I'm
if-
sorry.
If it's conclude, if you're just concluding, then that's fine.
Yes.
No argument, just
No
conclude.
argument, Your Honor. For the reasons set forth, the appellant respectfully requests that the court reverse and vacate the trial court's July 26, 2018 judgment entry. Thank you, Your Honor.
Very good. Thank you both for your arguments. It's an interesting case, as all of the cases we hear are. The court will take the matter under advisement and issue a decision in due course. The day the decision is released, the clerk will mail you each copy of the court's decision. Now, you can also keep an eye on the Supreme Court of Ohio's website where the opinions are also posted. Thank you again for your